Welcome back. We've been following several developing legal stories involving the White House this evening, including now a new one concerning Michael Cohen. Yes, there's another one. As first reported by the Wall Street Journal, an attorney for Donald Trump's former fixer discussed the possibility of a pardon with one of the president's attorneys last year after federal agents raided Cohen's home and office. NBC News has learned that there was more than one conversation about a pardon, and that Congress is now looking into whether the White House used the promise of a pardon to coax Cohen to continue lying about those hush money payments. Meanwhile, the House Oversight Committee Chairman Elijah Cummings is accusing the White House of defying the Constitution for refusing to hand over documents in connection with its investigation into the Trump administration's security clearances, including Jared Kushner's. Now, the White House counsel called the committee's demands unprecedented and extraordinarily intrusive. Then again, we've never had a situation like this with a security clearance before. And then they also claim that he's overstepping his authority on his committee. With me now is Chuck Rosenberg, a former U.S. attorney and a senior FBI official. He's now an MSNBC contributor. Mr. Rosenberg, let me start with the pardon story. And here's where I'm trying to figure out the legal issue here, pure legal issue. If the president has this power to pardon, then ultimately whether he broke the law or not is not up to the Justice Department. It would be up to Congress. So what is is there a legal investigation to be done that's different from Congress's investigation into the idea of dangling a pardon?
You know, I think there is, Chuck, and it's a hard legal question, but here's how I think it would play out. The Constitution gives the president extraordinarily broad pardon powers, right? There's only one limitation on it in the Constitution, which is in cases of impeachment. But let's say a president sold a pardon, right? Chuck Todd is in trouble. Chuck Todd coughs up $5 million in cash.
Chuck Rosenberg, we had a governor of Tennessee that sold pardons, I believe, in 1977, 78, as he was walking out the door. But anyway, this wasn't a theoretical. But anyway, go ahead.
Well, but it would have been under the
State
Tennessee
Constitution. Yes.
Right,
Yes.
not under the U.S. Constitution. But let's say that you, Chuck Todd, cough up $5 million in return for a presidential pardon. Right. Or let's say that in return for your pardon, you agree to lie to the FBI or to withhold evidence or to remain silent. Even though the Constitution says the president's pardon authority is broad, I don't think any logical construction would say it's broad enough to cover crimes. We'd have to litigate it. We'd have to find out. But I think that could be construed. In fact, I'm confident that could be construed as an obstruction of justice if it happened.
Well, we had the Mark Rich pardon. And now, granted, it never got, if you recall, this was somebody who Bill Clinton pardoned toward the end of his presidency. And the accusation simply was that his wife, he was not in the United States, his wife essentially bought the pardon. She started contributing a lot of money and then got meetings and all of that stuff. But where is that illegal?
Well, again, tough question. I'm not wholly familiar with the Rich pardon, except to know that it happened out the door under strange circumstances, and it looked tawdry, to say the least. But again, I think you can make an argument that if you sell a pardon, that is not in any way what our founders envisioned when they gave the president broad pardon.
So what would you
authority.
do with that? Is that an indictment? Is that a grand jury? Is that something you would challenge the Justice Department's authority about whether they can indict a sitting president?
Well, it could be a non-sitting president. Remember, every sitting president becomes a former president at some point. And so if a president actually did that, and you could prove it beyond a reasonable doubt, you could always wait till a president is no longer president and bring that charge criminally.
Let me go to the Jared Kushner situation, because it does seem as if that this is, and the back and forth on executive privilege here are just going to be tremendous. And obviously that in some of it's a political strategy by the White House to just delay, and I understand that. But what do you think is going to be the difficult case for Congress to make to get some of the information they need on Jared Kushner?
Yeah, and it may be a difficult case. So there is a legitimate thing called executive privilege. In 1974, when the Supreme Court ruled in U.S. v. Nixon that Nixon had to turn over his tapes, which led to his downfall, of course. In that very same opinion, they said there is a qualified executive privilege. And so it's hard for us sitting here today to know exactly what the Congress wants and over what the White House is asserting executive privilege. That's going to probably be litigated unless they can reach some sort of accommodation. And right now, the two sides seem relatively far apart.
I want to ask you something about that has to do with the judiciary request that came yesterday from the committee there. And that goes to securing the Mueller evidence. I looked at what they did, and it seemed to me that priority one was securing all the evidence that Mueller had. And I guess my question is, where does that evidence go? And why can't it be turned? Is that up to the Department of Justice solely, the Attorney General solely, to turn that evidence over to Congress if they ask for it?
Well, let me take the first part first. Some of that evidence that Mueller amasses, right, is going to be either protected by Rule 6E of the Federal Rules of Criminal Procedure, lawyer way of saying grand jury information, which you can't just turn over to anyone else, or it could be classified, or there could be ongoing investigations. So it's not clear to me that everything in Mueller's report can easily go to the Congress or be made public. That's something that Barr is going to have to decide. To your larger point, Chuck, it seems like the Congress has at least a couple of reasons to get as much stuff as it can. One is for its own oversight responsibilities, its own investigations. And the other, of course, is perhaps, as you surmise, to make sure as much of this stuff doesn't just disappear if the Mueller report can't be made public in whole or in part.
When does evidence get destroyed when you're done with it in an investigation? How does that work?
In a routine case, we keep it for years and years in the U.S. Attorney's Office until all appeals are exhausted, until the Supreme Court denies cert, and then we probably keep it for another decade. So we hold on to stuff for a long time as federal prosecutors until we're absolutely positive nobody needs it anymore.
Well, that's what I was counting on, the pack rats of justice. Chuck Rosenberg, as always, sir, thank you very much. Much appreciate you sharing your expertise with us. Hello, YouTubers. If you're watching this, it means you've checked out our channel, so thank you. Now do me a favor, subscribe by clicking on that button down there. Click on any of the videos to watch the latest interviews and highlights from MTP Daily and MSNBC. You can get more Beat the Press content every morning in the First Read newsletter. If you're tired of content that you don't know anything about where it came from, you don't have to have that problem with us. NBC News, MSNBC, MTP, and the Meet the Press mindset right here for you on YouTube. Subscribe now.